This will be the second video on the UCC connection, how to free yourself from legal tyranny. And we left off on section 28, page 26. The Rothschilds' influence. When America was founded, the Rothschilds were very unhappy because it was founded on the Christian common law. The common law is based on substance, and this substance is mentioned in the Constitution as silver and gold. America is a constitutional republic, which is a union of the states under the Constitution. When Congress was working for the for the Republic, the only thing Congress could borrow or issue was silver or gold, and the Rothschild banks did not lend silver or gold. Naturally, they did not like this new government. The Rothschilds had a deal with the King of England. The king would borrow paper and agree to repay in gold, but these United States, with their constitution, were an obstacle to the Rothschilds, and it was much to their advantage to get the colonies back under the king. So the Rothschilds financed the War of 1812 to bring America back under the British crown. It didn't work as planned, so they had to find another way. Section 29. The flaw in the Constitution, two nations in one. Around the time of the American Civil War, they discovered a flaw in the Constitution. The flaw was Article 1, Section 3, Clause 17. Remember, there are two nations called the United States. What is a nation? See if you agree with this definition. Whenever there is a governing body having a prescribed territory containing a body of people, this is an easy to understand restatement of the definition presented in Black's Law Dictionary. Is this a nation? Yes. We have a governing body in the Republic, a three-branch government, legislative, executive, and judicial branches under the Constitution. We have a prescribed territory containing a body of people as a constitutional republic. But Article 1, Section 8, Clause 17 gave Congress, the legislative branch of the three-branch government, exclusive rule over different territories containing a body of people, District of Columbia. Here we have a nation within a nation, a legislative democracy within a constitutional republic. When Congress was part of the constitutional republic, it was obligated to provide a medium of exchange for the people. Its duty was to coin silver and gold. Anyone who had a piece of silver or gold could bring it in and have it freely minted into silver or gold coin. This was a medium of exchange for the republic. But in the legislative democracy over Washington, D.C., Congress is not limited by the Constitution. Congress has exclusive rule over the District of Columbia and its people, subject slaves. The legislator in the District of Columbia can make the laws by a majority vote because the District of Columbia is a democracy wherein their administrative agents enforce their own laws and the administrative courts in their government try their own laws. Here we have the legislator making the law, enforcing the law, and trying the law, all within one branch of government. This is a one-branch government within a three-branch government. Under the three-branch government, Congress passes laws which must be in harmony with the Constitution. The executive enforces these laws passed by Congress, and the judiciary tries these laws passed by Congress pursuant to the Constitution. The three-branch constitutional republic and the one-branch legislative democracy, both called the United States. One is the continental United States, the other is a federal United States, federal zone. Section 30. Are you a United States citizen? If you say that you are a United States citizen, which state are you referring to? Anyone who lives in the District of Columbia is a citizen of the United States. The remaining population in the Union of 50 states are national citizens of the nation. Now, as I said before, this book was made in 1990, and through my great amount of due diligence, and we look at the GPO Styles Manual that is recognized by the federal government, a national citizen is not what you want to be. you want to be a Arizonian, a Coloradoan, and you'll find this in the GPO Styles Manual of 2016, page 95, chapter 5, 5.21 and 5.22 will clearly articulate the difference. So go check that out. Of the nation. We are domiciled in various sovereign states and protected by the constitutions of those states from any direct rule of Congress over us. And again, the GPO Styles Manual 2016, page 95, chapter 5, 5.22 and 5.21 will explain exactly what this man just said. Because he's telling you you're from a nation. Each 50 state is excuse me, its own independent nation. And so you're a nation of people from that nation, and you're protected by that nation's charter. All right? So go check it out. And again, this is all about words. If you're using certain words, believing them to have certain meanings, yet you haven't done the research on the vocabulary you're using or how to communicate with the entity to separate yourself, you may be failing in that aspect. And remember, they don't have an obligation to tell you why or what mistakes you've made that they're denying your paperwork and they're denying your status, but it's up to you to figure it out. And when you do figure it out, it will go through. Your paperwork will go through. In the democracy, anyone who lives in the state known as Washington, D.C., Guam, Puerto Rico, or any other federally held territories is a citizen of the United States, Washington, D.C. We must be careful with our choice of words. We are not citizens of the United States. We are not subject to Congress. Congress has exclusive rule over a given territory, and we are not part of that territory. Where did Congress get the authority to write the International Revenue Code? It is found in Article 1, Section 8, Clause 17 of the Constitution. To pass that law, they only needed a majority vote. There is no other way that they can pass laws directly affecting individuals. Title 26, the Internal Revenue Code, was passed as law for a different nation. Remember our definitions of nation. Title 26 is not consistent with the Bill of Rights. If you try to fight the IRS, you have no rights. The IRS code does not give you your constitutional rights. It simply says you failed to file an income tax form. You failed to perform in some specific manner. Remember, under the common law, you are free to do whatever you want to do as long as you do not infringe upon the life, liberty, and property of anybody else. If you do not want to perform, you do not have to. The only way you can be compelled to perform under the Constitution of the continental United States is if you have voluntarily entered into a contract. But if you are not under a contract, you cannot be compelled to perform. You cannot be compelled to file an income tax form. When Congress works for the Republic, every law it passes must be in harmony with the Constitution and the Bill of Rights. But when Congress works for the legislative democracy, any law it passes becomes the law only over federal territory. If you are charged with the willful failure to file a 1040 income tax, that form is of and for a different nation. You are a non-resident alien of that nation. It is a foreign corporation to you. It is not the Republic of the continental United States coming after you. It is a foreign nation, the legislative democracy of a foreign nation coming after you. If you get a notice of deficiency from the IRS, it is a presentment from the federal United States, so you can use the UCC to dishonor it. And you can tell the IRS that you are among national citizenry of the continental United States, that you are a non-resident alien to the federal United States. You never lived in the federal zone, a federal territory, and you never had any income from the federal United States. Furthermore, you cannot be required to file or pay taxes under the compelled benefit of using the Federal Reserve notes because you have reserved your rights under the common law through the UCC 1308. Section 31. Original intent of the founders. The founding fathers would never have created a government that was going to boss them around. there were 13 sovereign states. They were nations which they joined together in union for protection from foreign enemies. They provided means by which the union of sovereign states could fend off foreign and domestic enemies. But they never gave the Congress of the federal United States direct rule over any citizen of any union state. They were not going to be ordered around by the government that they set up. Section 32. Federal region, the federal zone. The Supreme Court has declared that Congress can rule what Congress creates. Congress did not create the state, but Congress did create federal regions. So Congress can rule the federal regions, but Congress cannot rule the states. How we have been tricked into federal regions. The zip code trick, Section 33. Remember how the government always comes to use and says, I'm from the government and I've come to help you out. The government went to the various states and said, we don't want you to go to all that trouble of writing 3 or 4 letters to abbreviate the name of your state, such as ARIZ for Arizona. Just write AZ instead of ARIZ, or you can just write WY instead of WYO for Wyoming. So all of the states of the Union have been given new 2-letter abbreviations. Even a state such as Rhode Island has a new abbreviation, RI instead of RI, R period I period. They just left off the periods. When you use a 2-letter state abbreviation, you are compelled to use the zip code, the zone improvement code. And I identify it as the Zone Improvement Project, but I believe there's a different name for ZIP. Because there are many states which start with the same letters. For example, ME is Maine, MI is Michigan, MS is Mississippi, with MA, MO, MN, and MS, etc. And some sloppy writing, and you could not tell one from another. So we use the zip code in order to tell them apart. But if you wrote MICH or MINN period or MISS, there would be no problem telling them apart. There's no harm in using the zip code if you lawfully identify your state. I found out that no state legislator has met to lawfully change the abbreviation of their state from its old abbreviation to the new. Therefore, if you do not use the lawful abbreviation for your state, but use the new legal shortened abbreviation, you have to use the zip code. Now, I don't agree with his hypothesis on using the zip code at all, because it falls underneath the DOD, the Department of Defense. It's a militarized zone, and I just avoid the being part of the corporation altogether on that aspect. And under the Domestic Mail Manual 602 1.3E2, you're actually exempt from using the zip code. Not only are you exempt, but it's also voluntary, and we found that in DMM 1.22.32, I believe it is, 32 or 23. I'm doing this off the top of my head. But that was later repealed and fell into DMM 602 1.3E2, which shows you that you don't have to use a zip code. You don't have to participate in their system. So look on page 11 of the zip code directory, and it will tell you that the first digit of your zip code is the federal region in which you reside. If you use AZ for Arizona, you cannot use the state constitution to protect you, because you did not lawfully identify your state. You use the zip code, which identifies which federal region you live in. Congress may rule federal region directly, but it cannot rule the citizens of any state. Accommodation party, Section 34. Let's look at how the state have become the accommodation party to the nation's debt, to the national debt. Many people who I have talked to, including the governor, are very concerned about this and know that it could happen very soon. If America is declared a bankrupt nation, it will be a national emergency. But let me remind you, ladies and gentlemen, they've been declaring us bankrupt for over 50 years. Every year, the president signs another declaration of emergency to keep the emergency funds flowing and the martial law in place, the soft martial law in place. FEMA will take over, and anyone who opposes the creditor's new government can be sent to detention camps in Alaska. We will have no rights whatsoever. They have already set up prison camps with work camps nearby so the people can be used for slave labor. Well, I've got news for you. You're already being used for slave labor if you're not going to have an ascension of the mind and learn how this system was set up and what to do in order to navigate, because freedom is not free. And are these internment camps set up? I do believe that there are facilities set up. If anything that I have learned through all my dedicated research is that history repeats itself. And let's not forget, what was it, in like 1948, we locked up all the Japanese here, even if they were born on American soil and had American parents, they were put in internment camps. So if you don't think history will repeat itself, you don't think they'd stick your family, your friends in a damn cage out in the middle of nowhere, you're sadly mistaken. Because honestly, these people don't care about you. They care about their nice cushy life and the next big deal they can make with pharma or some military industrial complex or the next country they can invade, loot, plunder, and steal, and use companies like Halliburton to siphon money out of the government to line all their friends' pockets. So they don't care about you, and that's important to understand that. It could be the governors, legislator, and other leaders who would be hauled away to Alaska, while the people now disenfranchised from power would likely be chosen to run the new government. This could all happen very soon, as the national debt is so large as to be unpayable. Even the interest on the debt is virtually unpayable. And the interesting thing about that, ladies and gentlemen, is he was writing this in 1990, and here we are coming upon 2020, and his hypothesis is almost spot on. We just had an impeachment, and not that I'm very political at all, but I think it's interesting. We just had an impeachment on a president, and the impeachment was filed before the phone call ever took place. Isn't that something? So you impeach a man on the grounds that you thought he might break the law at some point? If you don't believe me, go do your research. It's really comical to see what these Democrats and Republicans, or however they want to identify themselves, how they operate. Their modus operandi is amazing to me. And I'll tell you what, the good ones that actually get into it for the right reasons on day one are told you're going to go along to get along, or you won't last very long around here. And you gotta take bribes from these corporations and handouts and help push their bills so they can push their products down the people's throats. And that's truly what the government is at this point. It's all business, baby. And until you figure that out, you will never be able to ascend to the mind. You've got to know that by now. This is all business all the time, 24/7, holidays and all. It's all business. And as soon as you can grasp that, then you can move forward in this and start to assert yourself properly and conduct business that benefits you and your family. So you're not giving everything to the government when you perish. You're leaving it to your next of kin. You're leaving it to your friends and your family, because you understand how trust law works, and you're reading that good book, and you're taking these lessons, because things aren't too far gone. They can't be fixed. But what it takes is for a lot of good men and women to stand up and become learned, bind themselves together, and go before your local communities and educate the people. That's the most important thing to be had at this point. The federal United States had to trap the state into assuming the debt obligation of the federal debt. In the UCC, we find the term accommodation party. How did the state become the accommodating party to the federal debt? The federal government forced the state to deal in Federal Reserve notes, which means that everything that the state does and have done is colorable under the colorable jurisdiction of the UCC. All of the states are accommodation parties to the federal debt. The concern now is to find out how we get out of this situation. I told the governor that in the common law and the law of merchants, the international law of merchant, there's a term called no interest contract. A no interest contract is unenforceable and void. What is a non-interest contract? Section 35, non-interest contract. If I were to insure a house that did not belong to me, that would be a no-interest contract. I would just want the house to burn down. I would pay a small premium, perhaps a few $100s, and insurance for $80,000 against fire. Then I would be waiting for the house to burn down so I could trade my small premium for $80,000. I would have no interest in living in or owning the house. Under the common law, this is called a no-interest contract, which is unenforceable in any court and therefore void. Section 36, unconscionable contracts. No-interest contracts are called unconscionable contracts. The section in the Anderson's Code on unconscionable contracts covers more than 40 pages. The federal United States has made each state an accommodation party to the federal debt, which could be proven to be an unconscionable contract. We should get some litigation into the courts before the government declares a national emergency, claiming that this state has no lawful responsibility for the national debt of the federal United States because it became an accommodation party to this debt through an unconscionable no-interest contract. If we have the legislation before the courts under international law, when the nation is declared bankrupt, the creditors would have to settle this matter first, and it would delay them. They would want the new government to appear legitimate, so they could not just move right in and take over the state, because it would be in an international court. This is very important at this time. Section 37, question and review. Note, these are some of the questions asked after the main lecture. Some are restatements of materials presented earlier, but they contain valuable information worth repeating. Section 38, courtroom techniques. Question, how did you box in the judge? Answer, this is easy to do if you don't know too much. I didn't know too much, but I boxed him in. You must play a little dumb. If you are arrested and you go into the court, just remember that in a criminal action, you must understand the law, or it is a reversible error at law for the court to try you. If you don't understand the law, they can try you and have to dismiss the case. They can't try you and have to dismiss the case. In any traffic case or tax case, you are called into a court. The judge reads the law and then asks, do you understand the charges? Defendant, no, Your Honor, I do not. Judge, well, what is so difficult about that charge? Either you drove the wrong way on a one-way street or you did not. You can only go one way on that street. And if you go the other way, it's a $50 fine. What's so difficult about this that you do not understand? Defendant, well, Your Honor, it is not the letter of the law, but rather the nature of the law that I do not understand. The Sixth Amendment to the Constitution gives me the right to ask the court to explain the nature and cause of the action against me. And upon my request, the court has the duty to answer. I have a question about the nature and the cause of this action. Judge, well, what is that? What do you want to know? Defendant, well, Your Honor, is this civil or a criminal action? Judge, it is criminal. If it were a civil action, there could be no fine, so it has to be criminal. Defendant, thank you, Your Honor, for telling me that. Then the record will show that this action against your name is a criminal action. Is that right? Judge, yes. Defendant, I would like to ask another question about this criminal action. There are two criminal jurisdictions mentioned in the Constitution. One is under the common law, and the other deals with international maritime contracts under admiralty jurisdiction. Equity is civil, and you said this is a criminal action, so it seems it would have to be under either common law or maritime law. But what puzzles me, Your Honor, is that there is no corpus delicti here to give this court jurisdiction over my person and property under the common law. Therefore, it doesn't appear that this court is moving under common law. Judge, no, this court is not under the common law. Defendant, well, thank you, Your Honor, but now you make the charge against me even more difficult to understand. The only other criminal jurisdiction would apply only if, one, if there was an international maritime contract involved, and two, I was party to it. 3, it had been breached, and 4, the court was operating in an admiralty jurisdiction. I do not believe I have ever entered into any international maritime contract, so I would deny that one exists. I would have to demand that such a contract, if one does exist, be placed on the record into evidence so that I may contest it. But surely this court is not operating in admiralty jurisdiction. You just put the words in the judge's mouth. Judge, no, I can assure you, we're not operating in admiralty jurisdiction. We're not out in the ocean somewhere. We are right here in the middle of the state. No, this is not admiralty jurisdiction. Defendant, thank you, Your Honor. But now I am more puzzled than ever. If this charge is not under the common law, nor under admiralty, and those are the only 2 criminal jurisdictions mentioned in the Constitution, what kind of jurisdiction could this court be operating under? Judge, it's statutory jurisdiction. Defendant, oh, thank you, Your Honor. I am glad you told me that, but I have never heard of that jurisdiction, so if I have to defend myself under that jurisdiction, I would need to have the rules of criminal procedure for statutory jurisdiction. Can you tell me where I might find those rules? There are no such rules as statutory jurisdiction, so the judge will get very angry at this point and say, Judge, if you want answers to questions like that, get a licensed attorney. I'm not allowed to practice law from the bench. Defendant, oh, Your Honor, I don't think anyone would accuse you of practicing law from the bench if you just answered a few questions to explain to me the nature and cause of this action so that I can defend myself. Judge, I told you before, I'm not going to answer any more questions. Do you understand that? If you ask any more questions in regards to this, I'm going to find you in contempt of court. Now, if you can't afford a licensed attorney, the court will appoint one for you. But if you want those questions answered, you must get a licensed attorney. Defendant, thank you, Your Honor. But let me just see if I get this straight. Has this court made a legal determination that it has authority to conduct criminal actions against me, the accused, under a secret jurisdiction, the rules of which are known only to this court and licensed attorneys, thereby denying me the right to defend myself in my own person? He has no answer for that. The judge will probably postpone the case and eventually just let it go. In this way, you can be wise as a serpent and harmless as a dove. But you must not go into court with a chip on your shoulder and as a wolf in black sheep country. Remember, Jesus' words, I send you forth as sheep in the midst of the wolves. Be ye therefore wise as serpents and harmless as a dove. Sheep do not attack wolves directly. Just be an innocent lamb who just can't understand the charge. And remember, they can't try you criminally if you don't understand the charge. That would automatically be a reversal error on appeal. Section 39, the Social Security problem. If I were a young man, 18 or 20 years old, and just starting out in my first job, I would not want Social Security. Along with my signature on the application, I would write, without prejudice, UCC 1-308, to reserve my common law rights. But why wouldn't I want Social Security today? I got into Social Security system in the 1930s, and I paid into it dollars that had good purchasing power. Now I am getting a promised return in Federal Reserve notes, which have considerably less value. For example, in 1940, you could buy a deluxe Chevrolet automobile for $800. With today's Federal Reserve notes, that won't buy the rear fender and trunk on a new Chevrolet. If I were a young man, I would not want to put Federal Reserve notes into Social Security now and get back something later, like the German mark after World War I, when it took 1 billion marks to buy a loaf of bread. They will give you every Federal Reserve note back they promised you, but it might not buy anything. Section 40, Assurance of Performance. Under the UCC, you have the right in any argument to demand a guarantee of performance. So don't go to them and say, I want to rescind my SSN or I refuse to take it. Just go in easy. I would be more than happy to get a Social Security number and enter into this contract, but I have a little problem. How can I have an assurance before I enter into this contract that the purchasing power of the Federal Reserve notes I get back at the end of the contract will be as good as the ones that I pay in at the beginning? They can't guarantee that, and you have a right under the UCC to assurance of performance of the contract. So tell them, well, I cannot enter into this contract unless the government will guarantee to pay me at the end of the contract with the same value Federal Reserve notes that I am paying in. Both may be called Federal Reserve notes, but you know that these Federal Reserve notes do not hold their value. I want assurance on this contract that the Federal Reserve notes that I get in my retirement will buy as much as the ones that I currently have now in my working years. They can't make that guarantee. If they won't give you that guarantee, just say, I'd be glad to sign this, but if you can't guarantee performance under the contract, I'm afraid I cannot enter that contract. Now, did you refuse or did they refuse? You can get the section of the UCC which grants the right to assurance that the contract you have entered will be properly fulfilled, that the return will equal the investment, or you can reject the contract using the code. Using their own system of law, you can show that they cannot make you get into a contract of that nature. Just approach them innocently like a lamb. It is very important to be gentle and humble in all dealings with the government or the courts. Never raise your voice or show anger in the courtroom. Always be polite and build the judge up. Call him your honor. Give him all the honor that he actually deserves. He didn't rise to his position by standing on his thumbs. It does no good to be difficult, but rather be cooperative and ask questions in a way that leads the judge to say the things which you need to have in the record. Section 41, the court report. In many courts, there will be a regular court reporter. He gets his job at the judge's pleasure, so he doesn't want to displease the judge. The court reporter is sworn to give an accurate transcript of every word that is spoken in the courtroom. But if the judge makes a slip of the tongue, he might turn to his court reporter and say, I think you better leave that out of the transcript. Just say it got a little too far ahead of you, and you couldn't quite get everything in. So this will be missing from the transcript. In one case, we brought a licensed court reporter with us, and the judge got very angry and said, this court has a licensed court reporter right here, and the record of this court is this court reporter's record. No other court reporter's record means anything in this court. We responded with, of course, Your Honor. We are certainly glad to use your regular court reporter, but you know, Your Honor, sometimes things move so fast that the court reporter gets a little behind and doesn't quite keep up with it all. Wouldn't it be nice if we had another licensed court reporter in the courtroom, just in case your court reporter got a little behind, so that we could fill in from this other court reporter data? I'm sure, Your Honor, that you want an accurate transcript. I like to use the saying, give a bad dog a good name, and he'll live up to it. The judge went along with it, and from that moment on, he was very careful of what he said. These are little tricks to getting around in court. This is how to be wise as a serpent and harmless as a dove when we enter into the courtrooms. There are others using the same information presented here who ended up in jail, handcuffed and hit over the head, because they approached the situation with a chip on their shoulder. They tried to tell the judge that the law is, and what the law is, that he is no good scoundrel, and so on. Just be harmless and wise. Section 42, UCC 1-308, Review. It is important to know and understand the meaning of without prejudice, UCC 1-308, in connection with your signature. That we go over this once more. It is very likely that a judge will ask you what this means, so please learn and understand this carefully. The use of without prejudice, UCC 1-308, in connection with my signature indicates that I have reserved my common law right not to be compelled to perform under any contract I did not enter into knowingly, voluntarily, and intentionally, and I do not accept the liability associated with the compelled benefit of any unrevealed contract or commercial agreement. Okay? Once you state this is all the judge needs to hear under the common law. Both parties must enter into a contract knowingly, voluntarily, and intentionally, or it can be declared unenforceable and void. You are claiming the right not to be compelled to perform under any contract that you did not enter into knowingly, voluntarily, and intentionally, and you do not accept the liability associated with the compelled benefit of any unrevealed contract or agreement. The compelled benefit is a privilege to use Federal Reserve notes to discharge your debts with limited liability rather than to pay your debts with silver or gold coins. It is a compelled benefit because there are no silver or gold coins in circulation. You have to eat, and you can only buy food with a medium of exchange provided by the government. You are not allowed to print your own money, so you are compelled to use theirs. This is the compelled benefit of an undisclosed commercial agreement. If you have not made a valid, timely, and explicit reservation of your rights under UCC 1-308 and you exercise this benefit of the government, you will be obligated under an implied agreement to obey every statute, ordinance, and regulation passed by government at all levels, federal, local, and state. Section 43, Conclusion. The editor of this transcript has taken great liberties in putting this to paper in an effort to make it readable and somewhat compact. He wishes to offer his gratitude to Howard Freeman for the opportunity to work with the information so absolutely vital to our survival as dignified, unenslaved human beings. He must also ask Mr. Freeman's forgiveness for any errors committed in getting this to print. Its purpose, as stated in the foreword, is to make this knowledge and wisdom available to as many people as will take the time to read it. This is meant to be supplemental to Mr. Freeman's record lecture, not a substitute. Indeed, there is no substitute for hearing him personally present this material in his own words. It is not just the law and the facts that are important here, but the way they are used. His numerous reminders of Jesus' commissions to be like a sheep among wolves cannot be overstated, and is certainly good advice to use. In all dealings, not just in the court with the government, hearing him explain this in his own words brings to the life the particular application and usefulness of being harmless and wise. In fact, after being introduced to this approach, it becomes difficult to imagine that any other way of defending oneself from the government would be effective. Having said that, I feel obligated obliged to point out that one of the most difficult aspects of dealing with a licensed attorney, even a good one, may be knowing whose side he is on. After all, he is an officer of the court. So for those of you who have concluded that having an attorney means that you will soon be chained, gagged, and led to the gallows, this information may be indispensable. For the extraordinarily challenges of appearing in a court in one's own person, pro per, there are few reliable sources of information. Learning to defend ourselves, that is being responsible instead of turning one more area of our lives over to professionals, may be the only way to have any change of digging ourselves out of the legal tyranny. And with that, I'll yield the floor. We're on page 42, and officer of the court. So thanks for joining me.